Well, as you know, we all have our views on Ashley, Sir, as he is now. Lord knows that's ridiculous, but there you go. They give him away for rugby players, so you may as well give them to him as well, civil servants too. When Sir Ashley Bloomfield, we all have our views on his effectiveness and the message he gave to all of us during the COVID pandemic response of the last 3 years. He retired from that position as Director General of Health, as Public Health Officer and Director General of Health. And one of his last things to do, he was given the power by the government, was to be able to instruct councils throughout New Zealand to fluoridate their water supply. Now, 14 councils, I'm not sure which one they are, our next guest I'm sure will tell us, 14 councils who had up until then democratically chosen not to fluoridate their water supply. And I'm not an fluoridator person, so it's okay. You know, you're not dealing with an activist here from me. But nevertheless, I do believe in local democracy. But 14 councils who hadn't fluoridated their water supply in New Zealand were instructed to do so. And that was the end of it. So local democracy was removed and the bureaucrats in Wellington determined otherwise. And so this Community Fluoridation Act, I think it was 2021, gave the Director General of Health the power to direct local authorities to add or not to add fluoride to a drinking water supply. Lord knows when they would have, in actual fact, said not to add, but there you go. The idea of the legislation, according to the Ministry of Health, is to ensure a quote-unquote a nationally consistent approach to community water fluoridation based on its well-established health benefits. Well, a group of, one presumes, anti-fluoride people, here they are, here's the directions to fluoridate, I've got them now. A group of 14 councils in July of last year, 14 of them, were instructed that they had to put them in, and that they had until June of this year to comply, or presumably they would be found in breach and subject to prosecution. Others had a little bit longer. I see the Auckland Council, the Waiuku ward of the Auckland Council, had until 2026, but most were required to fluoridate either this year or next. And they included a range of councils. I see the small ones like Kauru, the big ones like New Plymouth, the small ones like the Tararua, and the big ones like Tauranga, for example. So you can see quite a range of councils there. Now, a group of folk took their New Zealand, or the Ministry of Health, and the Director General in particular, to the High Court, and they said, this is illegal. Last Friday, they won. To come and talk to us about this, and I'm sure she was involved in some way, is Mary Byrne of Fluoride Free New Zealand, and she joins us now. Mary, welcome to the show. Lovely to have you on.
Oh, thank you, Michael. Thanks for having me on.
Now, you're Fluoride Free New Zealand, but were you part of this legal action against the Director General of Health?
No, we weren't part of it. So, we know who they are and everything like that, and some of our members have spoken to them because, we've been studying this subject for a long time, so we've got a lot of background and evidence on it.
So did you were you involved at all in submitting evidence on this matter?
No.
So this group, how did they actually head off to the court without you?
Well, we've got an extensive website with a lot of information, so they would have been looking at a lot of the research that we've looked at, and we have sent them things. We've sent things like the National Toxicology Program review from the USA, all sorts of information about fluoridation. We've sent it into them so that they're completely aware of it all.
So why wouldn't they have involved you in this court action? Did they come to you at all prior to and ask?
Oh, we know them informally, but we're not part of the team doing the case. So yes, we talk to them and everything.
Right. Okay.
Yeah.
So they won last Friday, but they won on a sort of legal technicality. So it's not going to necessarily, as I understand, stop the fluoridation of those 14 councils. It just sends the decision back to the Director of General of Health to consider, as I read the judgment, and I'll be interested in your views, to consider the Bill of Rights Act before they make their final decision. Is that how you read it as well?
Yeah. So the Supreme Court in 2018 in New Zealand ruled that fluoridation was compulsory medical treatment and it violated Section 11 of the Bill of Rights, which is our right to informed consent to medical treatment. Mm-hmm. So that's established in our law in New Zealand. So what that meant was that the Director General should have done a consideration of to explain why he felt it was okay to override that fundamental right. So, as you most probably know, Section 5 of the Bill of Rights allows any of our other rights to be overridden if it is deemed to be a reasonable limitation in a free and democratic society. So, when you look at the ruling that the judge made, he's saying that every decision maker should consider the Bill of Rights, but there would be different onus depending on who you were and how big the effect on other people was. So if you were the librarian and you were telling someone they couldn't be in the library because of their T-shirt, he would expect that the librarian would give some sort of nod to the Bill of Rights, but they wouldn't actually have to know the actual wording of the Bill of Rights. And then it would go upwards, depending on the severity. So the judge says, at the top end, if you had a tribunal making a decision that affected a lot of people, he would expect an extensive review of the Bill of Rights or extensive consideration. So my view is that for the Director General to say that he's justified in overriding a basic human right, like our right to informed consent to medical treatment for every single New Zealander, then I would feel that is the top end. So he should have done an extensive consideration of the Bill of Rights. So explaining, why he thinks that Section 5 should be engaged. So it's going to go back to the Ministry of Health. Now, the ruling says that the Ministry of Health and New Health New Zealand could come to an agreement of what that consequence is. So the New Health New Zealand are saying that they want the directive to be put aside, to be suspended. Now, if that doesn't happen, the judge said he will make a ruling, and we think that the judge will make a ruling that those directives should be suspended. That's our guess on, our view. We think that that's likely. So if that happens, then we think that the councils of New Zealand the councils that have been directed, they need to stop continuing with trying to put in the fluoridation infrastructure, etc., because we think that the ultimate end of this is that fluoridation will become illegal. We don't think that the Director General really has a leg to stand on when it's properly reviewed in the full light of day.
I'm not so sure I agree with that. I'll explain why. I agree the Supreme Court upheld the Bill of Rights Act and it needed to apply before decisions. So, and you talk about, you're right, the right to the section that says the right to refuse medical treatment or etc. And so I don't have a problem with what the Bill of Rights Act says or your interpretation. But my understanding of the Health Fluoridation of Drinking Water Amendment Act 2021 of 2 years ago, that piece of legislation, Mary, was that they were trying to this was the government, get around that judgment and therefore directly give the Director General of Health the ability to direct local authorities to add fluoride to drinking water supply. Do you not see it that way?
No, I think that this latest ruling overrides that.
No, but all it says is that when he made the decision, this is Ashley Bloomfield, as the Director General when he went out, that he didn't consider it before he made his final decision. It doesn't say that the Bill of Rights Act will override whatever decision he might weigh. And it's clearly obvious that Parliament intended that he should have that power to direct local authorities to add fluoride to water supply.
Yeah, so the judge is saying that he should have given consideration.
Correct.
Right. And
that's right, yeah.
He didn't give consideration.
That's correct.
So, yeah, and then there is a substantive hearing that's going to follow on from this. This is part of the substantive hearing. So it's our view that in the substantive hearing that the likelihood is that they will find that it should be illegal rather than legal.
No, I don't read it. Okay, fair enough. I don't read it that way, because why would Parliament legislate to give the Director-General of Health and this the power to direct local authorities? Why? I mean, Parliament clearly intended that he should have or she should have that power, yeah?